straight ahead on Law and Crime Daily. Sentencing for a leader of a so-called sex cult.
Raniere was truly a modern-day Svengali.
Do prosecutors get their wish of life in prison or something less?
Plus,
lock him up! You murdered Paige! You're a murderer!
Our cameras capture a grieving family shouting down the defendant they say killed a young woman near Cincinnati.
And a baseball player accused of using a bat as a murder weapon.
Wielding the instrument of his profession as an instrument of death.
He blames the state for letting him out of a mental hospital. Law and Crime Daily.
Thomas and took a judicial oath before Chief Justice John Roberts. Barrett now begins her lifetime appointment to the court and is able to participate fully in the cases and controversies before it. The Senate vote to confirm Barrett was 52-48, one of the closest in modern history. The leader of a self-help group, which prosecutors say was also a sex cult, is learning his sentence. Terri Austin has that report for us now. Terri?
Aaron, this is the case of Nexium leader Keith Raniere. A federal jury found him guilty of every single count prosecutors allege. Raniere is among several Nexium members to be charged. A judge sentenced him to 120 years in prison. Others in the group included actress Allison Mack and Seagram's liquor heir Claire Rothman. Rothman agreed to forfeit $6 million as part of a guilty plea, which resulted in a sentence of 6 years and 9 months. Mack pleaded guilty, but has not been sentenced. Here's how prosecutors summed up the case when the jury convicted Raniere.
Raniere, who portrayed himself as a savant and a genius, was in fact a master manipulator, a con man, and the crime boss of a cult-like organization involved in sex trafficking, child pornography, extortion, compelled abortions, branding, degradation, and humiliation. His crimes and the crimes of his co-conspirators ruined marriages, careers, fortunes, and lives.
Victims addressed the judge. One said Raniere starved her to look like a 12-year-old and raped her.
Thanks for the update in that case, Terri. Another accuser has stepped forward to make claims against now convicted sex offender Harvey Weinstein. The New York Daily News reports that a 61-year-old woman filed a complaint with the New York Police Department saying that Weinstein forced her to perform oral sex at a nightclub in Manhattan in the 1990s. Weinstein is serving a 23-year sentence in New York, but faces an increasing list of charges in California. Weinstein denies that he committed any crimes. Ohio's top cop has a warning for anyone looking to post bail for a lawyer accused of selling women for sex. We first told you about Michael Moran on our last broadcast. He faces 18 felony counts of racketeering and promoting prostitution. Moran is accused of giving some of his clients drugs and trafficking them. The charges involve claims from 6 women over 15 years. Ohio Attorney General Dave Yost says Moran complained in court that he was poor and couldn't post his $300,000 bond.
One of the reasons that it's so awful is because this is a man who society gave trust to. He's a professional. He's a public official or a former public official. He's somebody with specialized knowledge. He can go places and knows things that other people can't go and don't know. And he used that to sell human beings. I just can't think of a worse abuse of trust. If you have the money and you have it in your heart to help this man and you want to give him the post of bond for him, that's one thing. But if what you're doing is buying his silence, then that's another crime and a furtherance of the racketeering enterprise. So here's my message to anybody that's thinking about posting bond for Michael Moran. You'd better make sure you're clean, because we're going to be watching.
The AG says there are more survivors out there who have information about Moran. The Attorney General's office wants to hear from them. An Ohio man making an appearance in court on charges he dumped a missing teenage girl's body more than 10 years ago. A trial date was expected to be set for Jacob Bumpas just outside Cincinnati, but a date wasn't set because his lawyers are still reviewing evidence. Bumpass is charged with tampering with evidence and abuse of a corpse in connection with the disappearance of Paige Johnson in September 2010. Johnson left her mother's home in northern Kentucky to go out with friends and was never seen again. Her mother said Bumpass admitted to giving Paige, who was 17, alcohol that night she disappeared. Prosecutors say pings from Bumpass's cell phone the night Johnson disappeared put him in the area where her skeletal remains were found earlier this year. An area nearby had been searched several times.
It's upsetting, but somewhat to be expected. I mean, we've never been through a trial before, but we watch TV, so, we know that this is going to take time. It's just kind of like a punch in the gut every time he gets to walk out and just be free and live his life. It just seems so unfair because she doesn't get to ever walk this earth again. We just want him to tell the truth. I was saying that in there with Scott O'Reilly, the prosecutor. I don't care about any jail time. If he would just tell the truth, tell us what happened.
A sheriff's deputy escorted Bumpass out of the courthouse as Paige Johnson's friends and family yelled at him and held signs calling for justice for Paige. The defendant is due back in court in December. Terry, Brian, let's jump in now here. So Terry, tampering with evidence and abuse of a corpse. The family is asking for higher charges. They want murder charges here. But I'm hearing one of the issues is that there's no cause of death. All that was left of the victim was her bones. Does that mean the defendant can't be charged with anything higher up the criminal ladder?
Not necessarily, Aaron, because listen, it's always easier to prosecute a defendant if you have the body and if you know what the cause and manner of death is. But actually, there have been plenty of instances where there has been a conviction with only circumstantial or forensic evidence. I mean, you remember, I think everyone probably does, the Jeffrey Dahmer case. He pulverized some of his victims and scattered all of their remains across the forest. And so it is possible. He was convicted, and he was convicted only on the forensic and circumstantial evidence. So it's possible. It's easier with the body and the cause, but it is possible.
So, Brian, I have to ask about the defense strategy here. Abuse of a corpse is a 5th-degree felony in Ohio. That's less than a year in jail. Tampering with evidence is a 3rd-degree felony. That's punishable by up to 3 years. What should the defense be doing right now?
At this point, they should be collecting evidence and they should be staying as quiet as possible. Right now, what we're seeing is that the pinging of a cell phone puts the defendant in close proximity to the victim's bodies or remains. And outside of that, there's not much connecting him to this case. So you really want to wait, see, and investigate to build a case to hopefully prove or try to show some reasonable doubt here.
And that will potentially be a tall order depending on how the rest of the evidence shakes out. Brian and Terry, appreciate the input there. Still ahead here on Law and Crime Daily, the governor of California making a legal argument that the death penalty is racist. Plus, the family of a man who died in police custody takes another step they hope will lead to justice. More on those cases and others when Law and Crime Daily returns. We have several civil rights cases to report, including a case involving the death of Javier Ambler in police custody. Brian Buckmire is here with more on a number of cases for us. Brian?
Thanks, Aaron. Civil rights attorney Benjamin Crump is suing Williamson County, Texas, over Ambler's death. Now, authorities say Ambler didn't dim his headlights for oncoming traffic, so they chased him, tased him, and ultimately killed him. A crew from the former A&E network show Live PD was riding along with the police. Crump says the police chases and violent encounters doubled in Williamson County because of its contract with Live PD. Now, tweeting about the case, Crump says Williamson County, Texas deputies cared more about dramatic content on Live PD than Javier Ambler's life. Cops must set priorities for citizen safety over everything, and we will not stop until we get justice and officers are held accountable. For ethical reasons, we must disclose that A&E owns a portion of the Law and Crime network, and the former Live PD host, Dan Abrams, is the founder of this network. Now, we're tracking upcoming hearing for the only police officer indicted in the connection with a botched police raid which killed Breonna Taylor. Brett Hankinson is due for a pretrial conference, but there seems to be some confusion among the court personnel over whether it will occur in person or via telephone. Hankinson pleaded not guilty to 3 counts of wanton endangerment for shooting into neighboring apartments during the raid. And finally, a white teen from Georgia will serve 4 years in juvenile detention after saying she's sorry for carefully planning a knife attack on a historically black church. The teen will serve an additional 10 years of probation after that 4 years. Prosecutors said the plot was racially motivated. It was foiled when classmates found out and told the school counselor.
Thanks a lot, Brian, for those updates. California Governor Gavin Newsom filing his own court papers to call the death penalty, quote, infected by racism. Newsom made the argument in a so-called friend of the court brief in support of defendant Dante McDaniel, who is currently on death row. Among the governor's arguments are that not enough blacks are selected to serve on juries, and their views are therefore not reflected in sentencing. African Americans' experiences have shaped their views of the criminal justice and capital punishment systems, Newsom wrote. He also said juries are disproportionately white and death-prone, heightening the risk that decisions will be based on racial bias. Those are the words of the California governor. So, Brian, I have to ask, do you agree or disagree with Governor Newsom?
I agree to the heart of it, maybe not the wording specifically. I do agree that when we look at others, and I'm not just saying looking at other people as you are another person in this room, but others who don't fit in our same group, we tend to not view them in the same light as those that we see in our community. And so sometimes those biases, even unconscious, can come forward in jury selection, in deciding whether or not someone's guilty or innocent, or depending on sentencing.
One of the most terrible things I think could happen in America, Terry, is that we would feel as though we're being judged based on our race by a jury or something like that. You want to be judged based on what you've done, what you've said, the evidence in court. You want to be treated fairly. And here, the governor is putting his stamp on the criminal justice system directly by actually filing court paperwork. It's rather rare for a governor to do that.
It is. You know, I actually saw Governor Newsom talk about this very issue when I was in the audience for a Van Jones show. And he is personally connected to this issue. He feels as though he doesn't ever want to be part of anyone getting sentenced to death. He feels as though defendants have a right to be judged by a jury of their peers. And he's making this argument that if, in fact, the black population is underrepresented and they're disproportionately discarded, then they're not being represented by a jury of their peers. So this is something that's close to his heart.
Yes, exactly. And he has put his words right in the court record at this point, so there's no guessing about where he stands on the issue. Coming up after the break, right here on Law and Crime Daily, a baseball player accused of using a bat to commit a triple murder. We take you to the California courtroom where that trial is unfolding right after this. A former Major League ball draft is on trial for allegedly using a baseball bat to beat 3 people to death inside a California home. Brandon Willie Martin faces 3 counts of first-degree murder for the deaths of his father, Michael Martin, his uncle, Ricky Anderson, and repairman Barry Swanson, who just happened to be there. Prosecutors say in 2015, Martin blew through his $800,000 in earnings, had no jobs, no friends, and no prospects. They accuse him of committing the murders out of anger, but his defense says he was wrongly released early after a mental health evaluation and claims the client is simply ill. Prosecutors are going for the death penalty.
He really was a man with no prospect. Really was somebody who'd been rejected as a Tampa Bay Ray, rejected by his family, and then he let his anger loose on those closest. He took that black baseball bat, engraved with his name, the name of his team, and he struck out at his family. First, he hit Ricky Anderson. You will find out that Ricky Anderson died of multiple blunt force injuries inflicted by the defendant. Barry Swanson, a man who truly was in the wrong place at the wrong time. Michael Martin used to sit in a recliner in the living room, and he sat in that chair. The defendant faced father, and with that black baseball bat, swung with the force of a professional baseball player and crushed Michael's cranium.
Gruesome pictures in this case, and remember, the defense opened with a concession that the state's facts are accurate. But the defense said their client's mental health was falling apart and called out the state for releasing him early from an institution.
but you're going to see a picture emerge of Brandon Martin, a picture that shows that between 2011 and 2015, his mind was changing. He was decompensating. He was going through things that he could not control, and his family worked very hard to attempt to work with. And it came down to, on September 15, the family at wit's end called law enforcement. But there's no question that Mr. Brandon Martin was going through significant mental health issues that were attempted to address. But then less than 48 hours later, he was cut loose, sent on the street. Here's a bus pass, don't go home. Or else you go.
And when we come back, more from this case involving drugs, alcohol, and baseball bats. Surprising testimony from the defendant's cousin, and our analysis in the case against Brandon Willie Martin. Back now to the California trial of a man charged with triple murder. Brandon Willie Martin's short-lived professional baseball career was marked by alleged cursing at coaches, failed drug tests, and a fractured thumb. Authorities say they found a black baseball bat covered in blood. Etched into the bat was the defendant's name. His own cousin said the family wanted to get him mental health care, but hesitated because they didn't want to ruin his baseball career.
He went from a nice, presentable person to someone that you could tell there was evil in his face, in his eyes. I want to say the first time I noticed it, I was asked to come talk to him by his mom.
Okay. So Melody asked you to go have a discussion with Brandon?
Yes, sir.
And do you know what year that was?
2015, I believe.
Okay. Was it close in time to the incidents that we're going to talk about?
Maybe within 6 months. When I saw him, I didn't see, when I saw him at the house, I didn't see that me talking to him would do any good after looking at him.
On cross, the defendant's cousin said he was the one who called police just days before the attack, but after the family attempted some sort of intervention.
The goal was to have him arrested, taken away from doing harm to the family, and then work on getting him help.
And when you were discussing help, you're talking about treatment, some sort of counseling, is that right?
Actually, I was looking into drug and alcohol abuse treatment.
Well, when the police arrived, Brandon was taken and placed on a 5150 hold.
Correct.
Okay. And you said earlier that you knew what that was.
Yes, sir.
Okay. What, at that time, what did a 5150 hold mean to you?
That it was taking him to a hospital for mental, like to see if he was, to evaluate him to see if there's a mental issue.
Those 5150 holds are California's version of a mental health hold. Licensed psychologist and law and crime expert Dr. John Delatorre says the defendant could have been held past the 72-hour window in that law if he was considered a danger to himself or others.
The Terrasoft Act in California, which gave psychologists and psychiatrists permission to break confidentiality in either a duty to warn or a duty to protect. Now, for the most part, the duty to warn in California has kind of been pushed to the side and everything's been focused on duty to protect. Here we have someone who has previously interacted in a negative way against his family. So he has a target, right? So we have, as a psychologist, a duty to protect. So the family should have been warned that he was going to be released, whether he was, 48 or the 72 hours. The family should have been warned, and he should have been kept inside the facility until they were for sure that he was no longer having those thoughts. And so for the defense, it sounds like he's kind of getting to mental state at the time he committed the offense, but doesn't seem willing to go the extra mile to actually get a criminal responsibility evaluation done.
So Terri Austin, what do you make of the mix between the defendant's mental health status and the attempt by the state to have him convicted and executed here?
You know, Aaron, it's clear that there's some mental illness here. You have witnesses testifying about it. You're going to have medical experts who are testifying about it. And Dr. Delatorre, you know, stated that clearly the family should have been warned about this. And for the prosecution to seek the death penalty, which means obviously he'd be executed here, I think that is somewhat unethical. I think when you have it clearly a defendant who has mental, you know, illness, then you should be seeking something less than the death penalty.
Of course, there's a moratorium on it in California, but that may change under another governor. Brian, got to ask the question about the insanity defense. The burden's on the defense in California. They follow the McNaughton rule. That means the defendant would basically have to prove he didn't understand the nature of his criminal act or that he didn't understand it was morally wrong. But we had the cousin testify that he saw evil in his face and eyes. I felt like that testimony was going right straight back at the defense tactic here.
Yeah, it's interesting. Even during the direct, that seemed to be very beneficial for the defense. I saw a deterioration of an individual that went from something this cousin could recognize to something that he described as evil and couldn't recognize. Over the course of that time and being close in time to the actual death and incident that occurred, plus the mental health issues, would have been a slam dunk.
I thought it played better for the prosecution, but that's just me. Hey, we're out of time here on Law and Crime Daily. We'll see you next time.